Hi, my name is Kubeir. Welcome to the channel. I am an ICCRC licensed immigration consultant, and this channel is all about Canadian immigration news, updates, processes, things you should do, things you definitely should not. And in today's video, I've been trying to do this video for the last 2 days, and for some reason it keeps falling flat, but I hope this time it gets up all fine and nice, especially with the audio. So this video is about the spouse open work permit applications and the changes that have been introduced to this processing of applications. This will actually impact mainly, amongst other categories, but from our audience, mainly who it impacts is the international students who are in Canada and also foreign workers who are in Canada. So before I complete anything else, let me start by telling you what all this will include and how this will go about. I will also show you the website, but don't worry about the link. The link is in the description box. You can always hop onto that and you can find out what is happening over there. Let me take you there. This is the link, or rather, this is the web page that you would be interested in figuring out what is happening here. Public policy, competitiveness, and economy. This is under section R205 of the regulations, Immigration Refugee Protection Regulations. These C41, C42, C43, C44, C45, these are all LMIA exempt codes. And all of these application types comes under the Canadian Interest International Mobility Programs. We are primarily interested in C41, and that is the spouses of the skilled workers or foreign workers in Canada, and C42, which is the spouses of the common law or spouses or common law partners of the study permit holders in Canada. Now, by and large, what the biggest change has been is the introduction of the term principal foreign nationals or the principal applicant. And in this particular change that has been introduced, the difference, henceforth, there would be only one principal applicant. And what I mean by that is that earlier what used to happen, or rather what they're trying to do is, that earlier international student would come to Canada. They would then, if they are eligible, they would sponsor or they would get their spouse to apply for an open work permit. The spouse comes to Canada on an open work permit. The spouse then gets a skilled occupation job, skill 0A or B. They get their salary, etc. They get 3 or 4 pay stubs. Now, in this position, the student who had come to Canada would leave their studies, would withdraw from their studies because obviously they didn't want to study. And by the fact that their spouse has a skilled job and is on an open work permit, and that spouse is eligible to apply for their spouse's open work permit. So this international student goes on to becoming that spouse's dependent and applies for an open work permit. So you see the circular fashion how this was operating. So first, the international student brings the spouse on an open work permit. International student leaves their studies and goes on to applying for an open work permit on the basis of their spouse already having an open work permit. Now, what IRCC has said is that there can be only one principal applicant, which basically means that if the principal applicant in this case was the international student, if the international student sponsored or got their spouse to have an open work permit, thereby in this particular family, this international student is the principal applicant. From here on, now, if this international student leaves the study, then the spouse who had now come on an open work permit cannot be the principal applicant, and therefore will not be able to allow their spouse to get the open work permit. So this was the loophole that has been closed. This has also been done under the section of C42, which is for international students, but also for C41. Now in C41, if you were coming to Canada on a work permit, so let's say you came to Canada on a closed work permit, you had an LMIA, your spouse came with you because the spouse would also be eligible to apply under C41. Now you would leave your job under this closed work permit, and then you would go on to becoming dependent on your spouse's open work permit, thereby applying for an open work permit. So you see how this was being used in a circular fashion. I wouldn't say it was an abuse of the system. I think it was there for people to use it, and hence it was being used. But this was obviously a loophole. It wasn't meant to be this way. Therefore, IRCC has gone ahead and closed these doors. So they made these changes. there can be only one principal applicant. Second change that has happened is that there is now going to be greater stress on proving the genuineness of your relationship. So obviously, since you are married or you're a common law partners, and therefore by that virtue, you are able to have your spouse apply for an open work permit. Earlier, the stress was there, but it wasn't, the emphasis was not on the genuineness of the relationship. Now this stress or this the emphasis is going to be much larger. They will be scrutinizing the genuineness of applications, basically to avoid the fraudulent activities that are prevalent, whereby people get into marriage just so that the newly married spouse could get some benefit in Canada by way of status, by way of permanent residence, by way of any kind of legal status in Canada. So obviously, in order to avoid that, the genuineness of the relationship will play a big factor. What you will need to do is obviously please provide chat histories, call histories before marriage, during the marriage, after the marriage, to show it's an ongoing relationship. You will need to show, anything that indicates that you guys were in a relationship, are in a relationship. This is a genuine relationship. Joint bank accounts, lease agreements, insurance beneficiaries, any fund beneficiaries, pension plan beneficiaries, whatever you can show in order to show that this was a genuine relationship, you will need to provide a lot of those documents. And third change that has come into play is that if you are an international student, you have to be studying a program or in a college which by itself allows you to apply for a postgraduate work permit. Only then will your spouse be eligible to apply for an open work permit. Yes, I know it's still true. It is still happening. A lot of people still fall into this trap. They come to Canada, enroll themselves in a college or an institution or a program where they feel that they will get a postgraduate work permit, but actually those colleges or those programs may not be entitled or eligible for you to be able to apply for a postgraduate work permit. This information is available on the CIC website. Do research for CIC DLI, the list of designated learning institutions. On the far right column, you will see PGWP on the top as a moniker, and under that, if it says no, means that college or program is not entitled for you to apply for a postgraduate work permit. If it says yes, then it's a safe bet. Obviously, go for it. This is something that you should be aware of. And all these three changes have been made, as I said, to close the loophole or sort of block this loophole that people were misusing, if you want to say, or abusing, if you want to say. But I would say that it was there to be used, so people used it. However, now IRCC wants to sort of clamp down on this and not have you do this anymore. This was a short video for me, which I have been trying to sort of put up for the last 2-3 days, but it was just not happening. I hope this time it's gotten there. Please do subscribe to the channel, as I keep saying, because we do obviously post a lot of quality content. If you're not following us on Instagram, then that's the link. Please do follow us on Instagram. We do post a lot of stories, short reels, which are very informative as well. And if at all you do want to make an appointment to discuss your application, your case, your process one-on-one, then that is the link. Come and see us, and we will be happy to sort of resolve your query. After all, I'm an ICCRC licensed immigration consultant, and by law, I'm legally authorized to give you immigration advice. Well, that's all from me for today. Thank you so much. Thank you very much for joining in, and I shall see you next time. Take care.